off with opening statements in the Manhattan hush money trial, where former President Donald Trump is facing 34 felony counts for falsifying business records to cover up a sex scandal during the 2016 election. Opening statements, they're a chance for both sides to set the scene and kind of build the narrative they hope sticks in the jurors' minds as they review evidence in the coming weeks. Unsurprisingly, there wasn't much agreement between prosecutors and the defense, including how to refer to Trump during trial. Prosecutors referred to him as the defendant, but his team said, "We will call him President Trump out of respect for the office he held." Prosecutors say this case is about a criminal conspiracy and a cover-up, all aimed at influencing the 2016 election. Trump's lawyer, Todd Blanche, got up and said, "Spoiler alert, there's nothing wrong with trying to influence an election. It's called democracy," he said. And the first witness took the stand this week, former publisher of the National Enquirer, David Pecker. And for the first time, he confirmed the agreement with Trump and his former fixer, Michael Cohen, to buy negative stories and bury them as Trump was campaigning for president. Pecker testified under oath that the deal to catch and kill included a $150,000 payment to Karen McDougal, who says she had a year-long affair with Trump back in 2006. And a reminder here, these payments, they are not disputed and they're not necessarily against the law, but prosecutors say that they were falsified in business records to avoid campaign finance violations. Also, something that came up this week with Pecker's testimony that you're likely going to see again throughout trial: hearsay objections. So hearsay is a statement made by someone who is not in court that's offered for its truth. That's not allowed to come into evidence usually because the person who made the statement isn't there in the courtroom testifying under oath about what they said in order to verify it. But there's a big exception to hearsay, and that's when a statement is offered for some other reason than its truth. For example, when you're trying to show the effect of that out-of-court statement had on the person that was also participating in the conversation. In Trump's case, the defense objected to Pecker testifying about something Steve Bannon said a long time ago. But Bannon is not there in the courtroom to verify it. So Bannon's words can only come in under a very few exceptions to the hearsay rule, and expect these hearsay objections to come up again. And while Trump was stuck in a Manhattan courtroom forbidden from attending oral argument at the Supreme Court, the justices considered whether he will have to stand trial for his efforts to overturn the 2020 election. Trump argues he is absolutely immune from criminal prosecution. Special counsel Jack Smith disagrees and actually has two federal courts to back him up on that. At argument, the justices seem to agree, at least in part, with Smith that the former president does not enjoy absolute immunity, blanket immunity from any possible criminal prosecution. But they also seem to think that there is at least some immunity for official presidential acts, even criminal ones. And the question of which acts count as official and therefore may be immune and left for a trial judge to determine, that could take some time. And for Trump, whose strategy has been to delay as much as possible, that could be a win.